The Honourable David Cunliffe.
Thank you, Mr Speaker. Mr Speaker, I rise in support of this bill along with my colleagues, but I do so, sir, with some comments that I think go to the heart of the bill's conception, construction and implementation. And if I can use a medical analogy, sir, this bill was flawed in its conception. It was mangled in its gestation. It would have been stillborn were it not for the midwifery that was offered by the opposition. And I'm sure that the Minister will have learned some salutary lessons from this process, because in all my time in this House, I have probably never, ever seen a worse official's performance in front of a parliamentary select committee. To say that they were not frank would be a great compliment. To say that the information presented to members of this House was partial would be undoubtedly kind. And there were real issues, sir, of probity when it emerged under cross-examination from my colleague, Mr Cosgrove, that officials briefing the New Zealand Parliament in a confidential closed session were at the same time carrying out negotiations with their Australian counterparts without reference to the Select Committee and without volunteering that information until it was dragged out of them. And I note that there are none actually present in the chamber today. Can I just say that I hope the Minister will take those matters up with the Chief Executive concerned, because it was, frankly, a display which was not befitting of the high standards that the New Zealand Parliament and the New Zealand Government normally expect. Mr Speaker, let me restate before I get into the meat of the bill where we in the Labour opposition and the government do agree, because there is some common ground, and that's the basis of why we are in fact offering our support for this vote. Firstly, of course, we support free and fair international trade. In general, we support closer economic integration with our largest market, our neighbour Australia, provided that that operates in terms of New Zealand's national interests. We supported the closer economic partnership agreement. We support within limits the single economic market limit that was actually kicked off by the Honourable Dr Michael Cullen, his counterpart Mr Costello in Australia. But it is worth noting, because it's an underpinning of this bill, that the current government changed the rules from pursuing those options which were in the interests of New Zealand and in the interests of Australia to pursuing anything which was in the interests of the totality, which means usually that it would be in the interests of the larger player but may not be in the interests of the smaller. And I say that the job of the New Zealand government is to look after the New Zealand national interest. And we were vigilant in this committee, and the government dropped the ball. Sir, the level of research contained in the regulatory impact statement and in the materials presented to the committee was desultory. There was no cost-benefit analysis to speak of to support the government's contention that the bill as proposed would have reduced compliance costs to New Zealand business. Now, the Labour Party supports the idea, as we support New Zealand business, that we do want to remove unnecessary compliance costs. And if it were the case that the patent attorney's profession was, shall we say, gold plating or feather bedding, that would be a legitimate target for government action. Except that there was actually no evidence presented to the Select Committee that that was in fact the case in any quantifiable manner. And the only submissions that were available to the Select Committee, both from the Institute and from New Zealand businesses, said the opposite, that the bill as drafted would have increased compliance costs to New Zealand and would have defeated its own purposes. And submissioners pointed out that the government's officials had not consulted with them in an open and broad-based manner. It was a bad process supporting a questionable idea. Mr Speaker, the performance of advisers in the Select Committee was not up to par, and that is putting it mildly. Not only was there not any form of rigorous cost-benefit analysis, but officials were not frank about the level of analysis that did exist. In other words, it sounded like there was some until they were cross-examined and we found out that the Emperor had no clothes on. And that should not be the case in the New Zealand parliamentary process. Secondly, as I've said, officials of the New Zealand government were having a parallel negotiation with their Australian counterparts, which resulted in the amendments which have been brought to this House. The trouble was they must have been giving them information about a confidential New Zealand parliamentary process while it was happening and without being frank to us that that was going on. And again, it was cross-examination from my colleagues which slowly but surely dragged it out of the officials what was actually going on, and it was reprehensible and bad process. Thirdly, officials contradicted themselves because they said that this bill was designed to enrich the intellectual property environment of New Zealand, and yet all of the evidence, all of the submissions rang warning bells that in the medium to long term the opposite would be the case. And the reason for that was contained in submissions was that it shifted the centre of gravity of IP formation and protection away from New Zealand to Australia, reinforcing a pre-existing process that corporate control, corporate head offices were already largely moving across the ditch, and high-end professional services were following them, and this would mean that the IP community was likewise. And while that may not have been a critical issue in the first year, it may have been a very significant issue over 10 years or 20 years, where it became more and more difficult to sustain intellectual property protection, IP law practices in New Zealand, and so trademarking and copywriting would be done in Australia. Yet another reason why, if you're an innovator, you would not locate in New Zealand. And that is a step which, if that had played out, and it actually won't to an extent that we consider dangerous because of the amendments, but if it had played out, it would have been directly contrary to the stated goals not only of the New Zealand Labour Party, but of the government itself, that we want to have a higher value, higher income, high knowledge economy. Well, why would we export our knowledge production processes to our nearest competitor? It made no sense. All right, if there had been evidence of a major cost advantage, but there was none, all right. If corporate New Zealand had lined up behind it, but they did the opposite, all right. If there had been good consultation and a reasonable level of acceptance by the profession, but there was the opposite. Just imagine that had been done to the New Zealand Law Society, or the Bankers Association, or Federated Farmers, or the Road Transport Federation. Why does the government have it in for the intellectual property profession? It beggars belief. Well, what was the end of the story? As I said, the bill was subject to a forceps delivery. There was quite a bit of pain. 2/3 of the bill was removed without anaesthetic. The single application process and the single examination process, which were the heart of the bill, no longer exist. They haven't been amended, they've been amputated. The only thing that is left in this shell of a bill, a fig leaf for ministerial process, was the joint training process, which allows New Zealand patent attorneys to be trained in Australian universities. Fair enough, because there currently isn't a proper course in New Zealand, although Victoria wants to put one on. And I do think, sir, that while we support this bill, we are going to need to monitor the long-term impact of the educational opportunities on both sides of the Tasman. And summing up, Mr. Speaker, as you will gather from my remarks, I have rarely seen a worse select committee process than this, and I would like to commend my colleagues for the way in which they handled that. They were temperate, sir, but they were also not going to let the issues go when officials were trying to do an end run around the New Zealand Parliament. And I'm pleased, sir, that they were able to hold them to account. Sir, I commend the Minister actually for having the courage to make the amendments that he's made, and that has afforded us the opportunity of supporting the bill. As I say, we support the principle of reducing cost where that can reasonably be done for the New Zealand business community. We support good international trade rules, and we support within reason a closer relationship with Australia. We will watch with interest to see what contribution the remains of this bill make.